So, good evening. So, now we will be having a session relating to the amendment of constitution. So, a very important content in the Indian polity is amendment of Indian constitution. So, literally speaking, when we go by the very basic term, what do you mean by amendment? The amendment per se is consisting of some changes. So, some change in the constitution. Sir, what the change will look like? So, typically speaking, we are more constrained to know what do you mean by the term amendment. So, amendment here generally denotes something which is being added, something which is being deleted, something which is being modified. So, addition, deletion, modification, all these things put together will be labeled as amendment. So, these three can happen. And number two, like the maker of Indian constitution, the drafting committee chairman B.R. Ambedkar, he has prepared the whole constitution. But now almost more than 75 years got completed. So, when B.R. Ambedkar prepared the constitution of India, maybe many things will be applicable at that point of time. Now, after 75 years, we can't expect the same thing to remain valid. So, certain provisions would have changed, certain rules would have got introduced in the parliament. So, many changes here and there are possible. When we want to incorporate those changes into the constitution of India, it should permit us to amend it. Here, it cannot say like a king can make no mistake. Therefore, what Ambedkar has given will remain permanent. No, that is not the case. So, here the constitution is getting the element of amenability only because of this procedure what is being found in the Indian constitution. Number two, going by the origin. See, as you all know, Indian constitution is made up of various type of sources. So, it is not like a single content. So, normally they say it is like a khichdi where we just get the content of various things. Likewise, Indian constitution has borrowed many provisions outside India to make the constitution of India. So, when we are having many borrowed content, now a question comes, what about the procedure for amendment? Have we made this amendment procedure on our own, or it is something a borrowed content? So, here factually speaking, this amendment procedure what we are discussing has been as such taken from South African constitution. South African constitution becomes the base from which we have as such imbibed the procedures or imbibed the content relating to the amendment procedure. On the other hand, in our Indian constitution, part 20 deals with the issue relating to amendment procedure. So, part 20 deals with the amendment procedure, and this has been borrowed from South African constitution, and number 3, article 368 is all about the amendment in the constitution of India. So, three things we have to remember. One is article 368, number 2, it has been borrowed from South African constitution, and number 3, most importantly, this particular amendment is found in part 20 of the constitution of India. So, these three, let it be the preliminary facts for you to by heart, so that any questions based on this in the examination, we can address it very comfortably. So, now we are done with the basic part. What do you mean by amendment? And here, what is the source of amendment and which article deals with the amendment, which part is covering the aspect of amendment. Now, we are done with these area. Now, moving on to the next one. Sir, now you have spoken about amendment. So, we are more concerned to know about how to amend the constitution. Does anybody is having the authority to amend the constitution, or practically speaking only few are given the authority to amend the constitution? So, in case of India, the constitution what we are following, which is otherwise called as the basic law of the land, is giving certain rules and regulation to amend the constitution. So what will come under this, when we can do it, and what are the procedure? Let us deal about that one by one in a detailed perspective. To begin with, number one, how to go for amendment. Practically speaking, if you want to make an amendment to the provisions what is there in the Constitution of India, for that you need to introduce a bill in either Lok Sabha or Rajya Sabha. The first point, be very specific. We need to introduce a bill either in the Lok Sabha or in the Rajya Sabha. Sir, here Lok Sabha, Rajya Sabha, are they equal when it comes to amendment of Constitution? Yes, they are equal. There is no big amount of difference in that. Here Lok Sabha or Rajya Sabha, among the two, anywhere we can do the task of introduction of the bill. That is the first point. Sir, what do you mean by bill? Because anything we speak here should have a proper meaning, right? So bill, typically speaking, a format, a type of structure what they have in the Parliament of India, where they can write and tell which part of the Constitution they are willing to change it. So the piece of paper in which they write what are the areas they want to amend in the Constitution of India will be called as a bill. This shall be presented in the Lok Sabha or in the Rajya Sabha. And now a question comes, sir, India is having so many states. Each state is having state legislature. Some states are having even state legislature and state legislative council. So can't the state legislatures do this task? Why you are giving only the Lok Sabha, Rajya Sabha? So our next point comes here, which says very clearly that in state legislature, amendment of Constitution is not allowed. If you go to a state legislature, they do not have the power to amend the Constitution. So amendment per se is considered to be the domain of Parliament of India. Only Parliament can do. So you know pretty well, Lok Sabha, Rajya Sabha, which can be holistically called as the Parliament of India, is the only authorized place where we can go for the amendment, and not in the state legislature. Their permission is being denied. You cannot do it. Number three, very important thing. Sir, what about the person who can come and introduce the bill? You are saying we need to go for introduction of a bill. Now the next question comes, who will be the person where he will come for the element of amendment? For this we have a beautiful answer. The particular bill can be made either by a minister or by a private member. Let's make this topic very simple, lucid and crystal, right? So here minister, a term which is very well known to every one of you. Either he can be a minister of any category, whether he can be a central minister or a minister of state or MOS, independent charge, whatever it is, any minister which belongs to or who belongs to the house of Lok Sabha or in the Rajya Sabha is eligible to introduce the bill. So first point is clear, minister, so a person who is holding the portfolio of a minister only in the central government, in the Parliament of India, is eligible to come and introduce the bill. So first point, we are very clear. Now next person, private member. So the term, if you just interpret in a colloquial sense, private member means anybody who is not a public authority will be called as a private member. So commonly speaking, this interpretation will come to our mind, there is no doubt in that. But here the situation is completely different. Always remember a shortcut to private member. Whoever is a non-minister, so not having the portfolio of a minister, but currently a MP in the Parliament of India will be labelled as a private member. So do not have any ambiguity, be very clear. A person who is not a minister right now doesn't have any amount of portfolio. Simply speaking, he is an MP, a member of Parliament. Sir, which house, sir? There is not a concern here. He can be a Lok Sabha MP, he can be a Rajya Sabha MP, any MP for that matter. A person who holds the portfolio of an MP will be called as a private member. On the other hand, a person who is a minister either from Lok Sabha or from Rajya Sabha will be labeled as a minister. Among these two, anybody can introduce the bill in the Parliament of India. So now third point is very clear. Now moving on to the next one, point number 4. Sir, we are going to do something, a big amount of activity, because we are going to amend the constitution itself, because constitution happens to be the basic law of the land. A question comes, do we need a prior permission from President of India? For that, the answer is big no. So, no prior permission from President. So, remember this point, very important. Prior permission of the President is not required. So, you need not have the separate amount of permission and all. Without having the President of India's permission, we have the right to move forward and go for the amendment of Constitution. Next one, point number 5. Each house, that is Lok Sabha and Rajya Sabha, must pass this bill, and this cannot be permitted on joint sitting basis. Sir, what is joint sitting? Suddenly a new term is coming here. Yes, I will decode that. Generally, there are some provisions where we can have joint sitting. Imagine Lok Sabha is saying okay, Rajya Sabha is not willing, the bill is pending for huge amount of time, and we need to bring some amount of consensus. At that point of time, using Article 108 of Constitution of India, they will go for a joint sitting. Lok Sabha members, Rajya Sabha members, all will come and sit together in a simple majority. If the bill is getting passed, then the bill will become an act once President is giving the signature. This is called as joint sitting. But here, for constitutional amendment, Lok Sabha and Rajya Sabha will pass the bill separately, and there is no provision of joint sitting, and here each house has to pass it separately. Now a question comes, sir, you are saying both the house must pass it separately. Imagine if one house has passed, other house has not passed the bill, they are just keeping the bill in abeyance. They are remaining silent. They are not giving any comment on that. Now what we are supposed to do? When there is no amount of answer coming from the one house, let's say Rajya Sabha. Lok Sabha has given the consensus. Rajya Sabha is remaining silent. What will happen? This bill will get lapsed. That's all. The fate of the bill will come to a grand end. Beyond that, nothing will happen. So the provision of joint sitting generally do not get an invitation for the amendment to Constitution of India. So they need to pass it separately. So this provision be very clear. Next one, that is point number 6. Sir, Lok Sabha has passed the bill. Rajya Sabha has passed the bill. Now what will happen? There are certain types of bill in which you need to get the permission from the states. Here I am not saying state government, I am saying state legislature. So state legislature means you all know it is a place where the laws are being made. So when certain types of bills are there which is affecting the federal structure of the constitution, at that time you need to get permission from 50% of states in case of India. So 50% of state legislatures must give the consent if the bill is affecting the federal structure. Sir, what is federal structure? I will come in the next slide. So now, when the bill is subjected to a normal bill, Lok Sabha, Rajya Sabha, when they both of them pass it, the President, if he is giving the assent, otherwise called as official signature, the bill will become act. There are special cases where the question of federal structure will come into picture. When that is happening, then you need to get the element of 50% of state legislatures giving their consent. Sir, they have to give the consent. Imagine, let us say in 28 states, 14 states are saying okay. Remaining 14 are not giving any reply. What will happen? No problem. if we get the approval from 50% of states in India, that is more than sufficient, nothing more is required. So 50% of states alone needs to give the permission, remaining 50% we are not bothered. A question again comes into our mind, sir, 50% you are saying, within what time they have to give the reply? Do they have any time factor, or they can just drag the matter for n number of years? For this, constitution is silent. They simply say 50% of members must give their assent. When 50% of states are giving the approval, that's enough. Time limit has not been codified in the constitution. Therefore, when a question comes, if a bill is in the nature of federal structure, if it is been sent to state legislature, within how many days they have to return the bill? No time limit. They can just take their own time and they need to give their reply. The moment 50% of state legislatures give the reply, then that will be considered as the entire India. All the states have given the approval. Okay, so now Lok Sabha has done, Rajya Sabha has done, the state legislatures have also given okay, as the matter is now relating to federal structure. What will be the climax stage? In this area, the bill will be sent to President of India. Now, President of India will be the final person to have his signature on this bill. A question again comes, sir, President of India is the person, authorized person, everything okay. But President is seeing the bill. Now he is saying, hey, come on, for this bill, I will not give signature. I don't feel like giving signature. What will happen? So this a general doubt into the minds of aspirant. But for this, we have a stricture made in the Parliament of India. What is that? 24th Amendment Act of 1971 have clearly mentioned that whenever a bill is coming to President of India, if it is in the nature of constitutional amendment, he must give his assent. So what is the word? He must give his assent. There is no question of he saying, no, no, I will not do it. Here he is duty bound to give his signature. Sir, now you are saying constitutional provision 24th Amendment 1971 he must give. Suppose President says no, I will not give the bill, what will happen? Then by default they will use Article 61. What is Article 61? Impeachment of President. They will start the bill to remove the President of India from the post of President. So this alone will be the final result. So President of India, you all know, he can be removed for a very common term called as violation of Constitution. There is no specific area. Violation of Constitution. In entire constitutional thing, if at all there is any point where President says no, next moment we can start the process to remove the President of India. And generally, any President will not do. Anything comes from the form of constitutional amendment, they will give the signature because they work only within the ambit of Constitution, so they will give the signature. Now, President has given the signature. The signature, what we call in a formal statement is assent, A-S-S-E-N-T, assent. So, once President is giving the assent, that's all. The particular bill will now become an act. So, bill will get converted into act. Always remember, don't write ACT for any of the act. It becomes a wrong statement. It should be always capital A, then CT. This is considered to be the official thing after President's signature. Then by default, this act will be applicable to whole of India. Earlier and all, they used to say this bill is applicable to whole of India except Jammu and Kashmir. But now after the integration, after 2019 August 5, most of the provisions are being made applicable to whole of India. No exemptions are given. This is the procedure in which we do the amendment. And for this, the last thing which we need to cover will be the aspect of types of majority which we are utilizing in case of this particular amendment. Types of majority. So, for anything and everything, we need to decide based on the majority. How many should say okay? How many, if they say okay, is it acceptable? So, we need to cover all those things, right? So, for that, we have types of majority. In that, number one will be called as simple majority, Number 2 will be called as special majority. Number 3 will be called as special majority plus state ratification. Simple, special, special plus state ratification. See, nowadays UPSC is now devolving into the constitution to ask questions even from a very deep perspective. So, we can't take it lightly. Sir has taught me in the class there are 3 types of majority. When a question comes in the exam, how many types of majority is getting mentioned in the Constitution of India? The whole class will believe 3 information has been taught. Come on, we will write answer as 3. But when you come home and check, this will become a wrong statement. 3 is there only for our understanding. So, for our perspective to understand the majority, we have 3. But in reality, as per Article 368 subclause 2, 368 subclause 2, there are only 2 types of majority. Number 1 special, number 2 special plus state ratification. We do not have the simple majority mentioning in the Article 368 subclause 2. So, when a question is being asked, how many types of majorities are there as per the Article 368 subclause 2, answer is 2 only. We don't have 3 types. So, the first one doesn't even or it is not deemed to be an amendment of the Constitution of India. So, be very clear. So, this particular simple majority what we are doing doesn't even get qualified to be called as an amendment. Therefore, as per Article 368 subclause 2, we have special majority, then special majority with state ratification. This is the content. Sir, now we have done with this area, special, simple and this special, simple and special with state ratification. Now, what and all will come under this area? What provisions will come under this area? That becomes a very big question. What will come? So, here what is simple, what is special plus state ratification. To begin that, generally speaking, if we deal with the simple majority, what and all will come? Specifically speaking, for example, the matters relating to citizenship. Number 2, the matters relating to delimitation of constitution. So, the number of MPs every state will be having, right? So, it is based on constituency. So, each constituency they will redraw the map which is called as delimitation, so that we can do it. Number 3, appointment of puissant judges. Who is puissant? Somebody who is a judge, definitely not in the rank of Chief Justice, but a rank less than that. He will be called as puissant judges. So, this matter. Then number 4, 5th schedule. So, 5th schedule will deal with what? Scheduled areas and scheduled tribes. Scheduled areas and the scheduled tribes will be subjected to this particular 5th schedule. Then we can just move on to the 6th schedule. Again, it is the content relating to the tribal people. So, 5th schedule, 6th schedule, delimitation, citizenship, the puissant judges, or even admission of a state, all those content put together will be coming under the element of simple majority. Number 2, we have special majority. What will come here? Amendment of fundamental right, amendment of DP, SP, and any of the matters which is not coming in, let us number it 1, 2, 3. Any of the matters which is not coming in 1 and 3. So, whatever doesn't come in first one, simple majority, whatever doesn't come in special plus state ratification, remaining everything will fall under this area. Next we have special plus state ratification. There are some provisions where we need to get the consent of 50% of state legislatures. So, where we can do it, under which area, just I have a small list of items, I will show that to conclude this topic, where we can go for the element of state ratification. Number 1, when we can do it? Election to President of India. If you want to make any changes in this, get the permission from 50% of states in India. Number 2, extent of executive power between union and state. So, executive power, who are executives? The person who come under the category of President, Vice President, Prime Minister, then Council of Ministers, Attorney General of India, all those people, executive powers. Number 3, distribution of legislative power between union and state. What is legislative power? Law making power, where when a person can make law, whether state can make law, center can make law. If you want to bring any changes to these area, you need to get the permission from 50% of state legislature. Number 4, Supreme Court and High Court. If you want to make any changes with respect to Supreme Court, High Court, it can be anything, appointment, transfer, whatever it is. So, any changes brought into this area needs 50% of state's permission. Number 5, any changes you make to 7th schedule of Constitution. 7th schedule of Constitution will deal with items like union list, state list, concurrent list. Union list means only central government can make law in these area. So, there are totally 100 items where only center can make a law. Then we have state list, where only state legislature can make a law, center cannot make a law. We have 61 items coming under this area. Then we have the last one called as concurrent list, where state can make a law, center can make a law, but at last the law made by the center will prevail. In this we have 52 items. If you want to change this, then definitely speaking, you need to get 50% of the state's permission. Then number 6, representation of states in parliament. That means anything relating to Rajya Sabha. So, states are getting represented, no. So, mostly issues relating to Rajya Sabha, any changes in that criteria will be subjected to amendment. So, we need to get 50% of the state's permission. And number 7, suppose if you want to amend Article 368 itself, I want to change the entire amendment process, then in this criteria we need to go by getting the permission from a great amount of 50% of states in India. So, these are the areas relating to the 3 types of majority. So, additionally there are other things also in this chapter. So, what is simple, what is special, when simple will be used, when they will go for effective majority, then what is absolute majority, then other content, what do you mean by special majority? We have 2 things, 50% of the total strength, then 2/3 of the members present and noting. So, those things we will deal in the upcoming sessions. Thank you.